Hello, everyone. We are here today to talk again about build it, protect it, pass it on. So this is the second of a series on asset protection strategies. The first one was the introduction. This is the SMSF strategies. And then the third one will be the advanced protection. Who are we? Freedom Financial Solutions is founded by myself, Cass Smith, also known as Catherine. For those that don't know me or want to look up my past, Mary Jane is the managing director, and Grant Abbott is our specialist estate planning strategist. So what are we going to talk about? Firstly, let's look at starting with the right questions. So do you have a plan if you die or suddenly become incapacitated? And I should have said earlier, these videos are quite difficult to make because it's talking about some really unpleasant topics. So many people in life just want to go through not thinking about the fact that they're human and things can happen and they might die unexpectedly, die suddenly, or become incapacitated by way of car accident, stroke, etc. As I said, very unpleasant topics, but believe me, it's better to think about it while you are still in the right frame of mind and still alive, rather than have an absolute mess if you haven't thought about it. And unfortunately, we are seeing a lot more sudden deaths and incapacity due to illness. So which has prompted us, Freedom Financial Solutions, we focus on self-managed super fund setups and accounting for self-managed super funds, but more and more we've seen the need that we need to help our clients with this topic, not only for themselves, but for their loved ones, their siblings, their parents, their children. So do you have a clear plan if you die or become incapacitated? Do you want to keep your wealth in your bloodline? So you don't want it going outside your bloodline to spouses, ex-spouses, stepchildren, ex-stepchildren. Will your superannuation go to where you want it to go? And who will take over from you legally, financially, and emotionally? They are the right questions to start with. And now we'll move on to how we can help you. So I covered this in the introduction video, but just very quickly, what is an estate? For those of you that don't know, it is basically all of your assets. Everything that you own or are entitled to own at the time of your death goes into your estate. And this is a wonderful little picture because it shows all your assets in a nice white picket fence, but there's a hole in the fence, there's a gap in the fence. And the sharks are circling. The sharks haven't found that gap in the fence yet, but believe me, they will. So the only things that don't go to your estate is your superannuation and your life insurance. Sometimes that will stay outside the estate unless you're specifically directing it into the estate. So that is your estate. How safe is it from attack? So let's have a look at some strategies. So what's at stake? Your home, savings, business, interest, super, bullion, property, shares, any other assets you've got is at stake. Your family's financial security after they're gone. And your wishes and legacy being carried out. And avoiding family disputes, court battles, and tax traps. So there is a lot at stake. It's not just your assets, if that's not enough. It's your family's financial security. You've worked hard during your life. You want your wealth to then go on to your future generations, spouse, perhaps children. You also want to make sure your wishes are carried out. Whether you believe in the afterlife or not, I don't want to be sitting up there looking down at all of my wealth just being dissipated to people. I don't want to have it. And then the last one is avoiding family disputes. I have heard so many horrible stories about families, maybe they had a few issues before death, but after the death of one of the family members, and they just absolutely fall into a major family dispute. Money does strange things to strange people, unfortunately. So what are the other risks? What risk are to your assets right now, even before you die? Is lawsuits. Someone can sue you. So after an accident or through business, your divorce or relationship breakdowns, unfortunately happen quite often. Financial troubles with bankruptcy or debt collectors. Bad business decisions. Made a few of them myself. If you've given personal guarantees or you've had a company that's failed, that can put your personal assets at risk. Poor insurances, if the assets aren't properly insured. And then the health issues that we spoke about, sudden serious illness or incapacity. You don't want to be making rush decisions. You don't want a sudden illness and you're already in a bad state of mind because you've been given a bad diagnosis, and then all of a sudden you are rushing to get everything in order. That's not the best way to go. So some of the common vulnerabilities that we see is no enduring power of attorney. Enduring power of attorney is instructions before you die. So if you did have that car accident, touch wood, stroke, etc., and you're incapacitated mentally, your enduring power of attorney can step in and make decisions. No will or an outdated will. Very important that you have a will. We'll talk about that. Assets held in your own name. That sounds strange, but it is a common vulnerability if you hold assets in your own name. The ultimate that all the wealthy aspire to is to control everything but own nothing. No plan for blended families, former partners, potential claimants. So blended families are just so common these days, with people having children with, say, one marriage, then separating, and then hooking up again with a new partner, and you've each got kids to previous partners. That is what a blended family is. Children inheriting too much too soon. This is one of my bugbears. I think my children are eagerly waiting for the day they get my estate, but little do they know that I've locked it up until they're age 30, because I don't believe they have enough wisdom before that age. Superannuation not being covered by your will, and exposure to divorce, litigation and creditors. So that is also upon death, if your assets go to one of your beneficiaries who is going through a divorce, litigation or creditors. You really don't want all your hard-earned wealth just to end up in your child's ex-partner. So who wins in a challenge? That is a very good question. Who wins in a challenge? The person that has the best case? The person that has the best lawyer? The person that has the most money so that they can pay for the best lawyer? I think everybody who's ever had anything to do with court cases and legal battles knows who wins in a challenge. The lawyers. And unfortunately, there are so many cases, estate planning being a very topical topic at the moment, where there is something called a no-win, no-fee lawyer. We've probably all heard of those in cases of, like, they used to call them the ambulance chasers, would chase an ambulance, and as soon as someone's had an accident, they'd go in and try and do a no-win, no-fee case to sue the person who crashed into their car or the insurance company or whatever. But unfortunately, we have that in estate planning now. People seek out, if your will and it goes into probate, there are no-win, no-fee lawyers that will seek out any potential beneficiary that could put a claim against you and try and start a case. Crazy. So here are some landmark cases. So Katz versus Grossman, a father intended to leave his SMSF equally to both his children, but his daughter appointed her husband as the trustee and paid 100% of the death benefit to herself, excluding her brother. That decision was upheld and the brother didn't get anything. But the most important thing is here the legal costs, up to $250,000 in legal costs. Next one, can't pronounce that, Apollo and Conti. A deceased husband directed his super to his children. Quite common. Excluding the ex-wife. Quite common. She attempted to assert her control of the SMSF as executor and legal personal representative and redirect the funds to her estate. The existing trustees lawfully retained control and excluded her from the benefit. So she didn't win, but legal fees are $400,000 to $600,000. Wareham versus Marcella, a daughter acting as trustee, paid 100% of her father's SMSF to herself, excluding the stepmother, the deceased long-term spouse. She failed to notify or consider her stepmother, and the trustee gave her the discretion to do this, but she acted without procedural fairness. That was overturned. The stepmother got the money, but legal costs of $500,000 to $700,000. Owls versus JJE nominees. After the father's death, the widow was excluded from the SMSF death benefit by her children. Acting as trustees, they paid the entire benefit to themselves without notifying her, breaching procedural fairness. So in that case, the kids were removed and a full rehearing was ordered. So this is probably even worse because legal fees of $700,000 to $1 million, and there's no even outcome yet, just the trustee got removed and it's going back to court. So these are examples. These are everyday people that their estates have just been decimated in legal fees. So real protection requires ensuring that your legal structures are complete and up to date. So what real protection looks like? Firstly, we look at the bloodline. We want to keep the wealth in your family bloodline. Oh, of course, you can choose to leave it to ex-partners or spouses, current spouses, or stepchildren, etc., but make that a choice and keep it in your bloodline if it's your bloodline you want to protect. We look at your legal structures, your trusts, wills, SMSF strategies. We look at the succession plans for you and your businesses and your trusts. And we have built-in defences against family provision claims and no win, no fee litigators. So let's start with your SMSF. So to be an SMSF trustee or director, you must be 1, mentally capable and actively involved in making fund decisions. So what happens if you become incapacitated? Firstly, so if you're incapacitated due to stroke, accident, dementia, unfortunately with dementia, it can come on so subtly you don't even notice it until it's too late. But once you are diagnosed with dementia, you can't legally act as trustee or director of your own self-managed super fund. You must resign or be removed as a trustee or director. You can remain if you have a valid enduring power of attorney. Okay, so there's the importance of having that enduring power of attorney. Because if you have no enduring power of attorney, the fund will become non-compliant and may need to be wound up or restructured. And your family may have to go to court to appoint a guardian or an administrator, costing significant amount of money. So we have a solution called a leading member SMSF, which simply enables your designated successor. So you choose in advance who you want to take over, and it just happens automatically without any of the problems mentioned above. So this just gives a bit of table of an explanation. So if you are an SMSF company trustee with a sole director, which a lot of our SMSFs are, and you become incapacitated and you don't have an EPOA, you must be removed as a director. You cannot act. You've lost your voting rights. Okay, if you become incapacitated. But if you have the enduring power of attorney, they're not a member, but they can come in and act as a director, take over the trustee role, assume control, and everything is maintained, everything is compliant. So they're very easy solutions. You just need to act on them and get them in place. So we can do this for you, which is check that your SMSF deed and the EPOA is up to date and correct. And check that you have a successor director set up or upgrade you to what we call a leading member SMSF. So who takes control? If you're a director of an SMSF trustee and you're a sole director, ask yourself, well, who's going to take over from you? Because you want it to be someone that you choose, not somebody that someone else chooses for you, the government trustee, for example. So if you'd like control over who is your successor director, you can see us and we will set you up a successor director solution. Some of these words are great tongue twisters. What if you are more than incapacitated? I shouldn't laugh at that. This is just Mary Jane put these slides together and her sense of humour comes in with that. More than incapacitated, I think she is meaning deceased. Once again, I shouldn't laugh, but sometimes you have to laugh just to get through some of these things because it isn't pleasant talking about these topics. What happens to your super when you die? So the money in your SMSF, including any life insurance in the fund, does not automatically go to your will or your estate. Super money held in trust by an SMSF, the trustee becomes responsible for deciding who receives it. Important thing there, SMSF is what we absolutely recommend. If you have money in a normal fund like a retail or a industry fund, the trustee of the fund, which is the managers of the fund, the directors of, say, BT Life or ComSuper decide. And there have been cases where they have decided not to give it to who you want to give it to. Terrible things. But the SMSF, we can, if we do all this appropriate paperwork, we can make sure it's all controlled for you. So the trustee must pay your super death benefit to somebody. Obviously it has to go to somebody, but only the people that the law allows, such as a spouse or a de facto partner, children of any age, or a financial dependent of your estate. Or your estate if you've nominated for it to go to your estate. And this is if you've given your trustee a clear, valid legal instruction, it's called a binding death benefit nomination, then they will have to follow it. But unfortunately, sometimes those binding death nominations are not necessarily clear or legal. Maybe they haven't been signed the right way or they've lapsed, which does happen. Then the trustee decides who gets the money and how it's paid. If the benefit goes to your estate, the will can control where it goes. And if you've set up a testamentary trust, your super can be protected and distributed tax effectively to your family. So how exactly does this happen? So when you die, you stop being a member of your SMSF. Your death triggers a member death benefit. And the SMSF must begin the process of dealing with your super balance. Your super money stays in the SMSF temporarily held in trust by the SMSF until the trustee distributes it as a death benefit. The trustee decides who gets it unless they're bound. So if you have a valid binding death nomination, the SMSF and the deed is correct and allows it, the trustee must follow it. But if not, your trustee has full discretion to decide who receives your super, as long as it goes to a cis dependent or your legal representative. Your death benefit must be paid as soon as practically possible, either as a lump sum, pension, or a combination. It cannot stay in the SMSF. After payment, your membership ends, your account is closed, and you are no longer connected to the SMSF. If it goes to your estate, that's your super benefit goes to your estate, your will then govern the distribution. So this brings up some important questions. Who will be the trustee in charge of your SMSF when you are gone? And have you left clear, legally enforceable instructions? So who controls it? So if you have an individual trustee SMSF, which is not as common because we really don't recommend that, but if you have individual trustees, the surviving trustee will control it, or unless you have appointed your legal personal representative, which is normally the executor of your estate, they can be appointed to act. If you have the standard corporate trustee, the remaining directors of the SMSF trustee will control the fund unless you have a will or a deed that directs otherwise. Our preferred, and this is where we are leading clients to, is a leading member corporate trustee. The reason for this is you get to nominate who is going to take over. So we set it up and you consciously decide who you want to be your successor. So it doesn't automatically go to the other trustees or the other directors, it goes to who you decide. And they assume full decision-making authority and must follow your SMSF will and death benefit. This prevents in-laws, step-family, or unintended parties from taking control. Unfortunately, we have seen so many cases where, as we said in those earlier cases, where the trustees, the kids took over the super fund and excluded the wife, or the spouse takes over the super fund and excludes the kids. So many different ways. So the leading member corporate trustee enables you to decide who you want to step in and act for you. So that's the important questions. Who will be the trustee? We've just discussed that. The next one is, have I left clear, legally enforceable instructions? So this is a good table to have a look at, which talks about a standard binding death nomination versus an SMSF will and testamentary trust. So a standing binding death nomination is if you have set up an SMSF with us, we do those as a part of the setup. I believe that's still the case, and it's better than nothing. But much better is the SMSF will with testamentary trust. Why? Firstly, let's look at the legally binding. So the standard, I'm just going to BDBN, only allows it if it's signed correctly and the deed allows it. Whereas the SMSF will, yes, it's built into the SMSF deed. It's definitely going to happen. The binding death nomination can expire. We do normally tick a box to say it doesn't expire, but sometimes the law makes it expire anyway. And whereas an SMSF will, it won't expire. It always remains valid. Flexibility with payments, no. The binding death nomination is just a lump sum, whereas the SMSF will can be a lump sum or an income stream. And tax planning options with a standard one is very minimal, whereas with a SMSF will, there's a lot of tax planning and effective income streaming that we can do, or your professional advisors can do, especially if there's minor children. Asset protection is very low with a standard death nomination. It's very high with an SMSF will because it leaves it to a testamentary trust, which protects it from divorce and creditors. Estate planning control with a normal death nomination is very low, very high with the SMSF will. We're splitting the assets between the beneficiaries. No, normally it's just you can split it with a binding death nomination, but with this SMSF will, you can actually split different assets. So you could say that the one beneficiary gets the property and another beneficiary gets the gold. Protection from bloodline, leaving it only to bloodline, standard death nomination, that's not guaranteed. If an SMSF will, yes, it's guaranteed and structured for long-term bloodline protection. Vulnerability to disputes, if the normal standard death nomination can't really be contested, but it can be invalid if it hasn't been signed properly or if it's lapsed. Whereas there's a lot lower risk with a SMSF will because they're embedded into the deed and the will. Requiring a renewal, that's good to renew the death nomination every 3 years, whereas the SMSF will is permanently in place unless it's updated. And also the fund can pay for the SMSF will. So, I mean, in summary, it's quite clear that the SMSF will with testamentary trust is preferred much better in tax planning and in asset protection and in bloodline protection than a standard binding nomination. And I always pride myself on the fact that we don't recommend anything unless we do it ourselves. And I actually did my SMSF will as of yesterday, because I'm about to go overseas for 8 weeks, and I just wanted to be sure that everything was in order. And I heard about these things, and I definitely did one, threw my binding death nomination out, and did an SMSF will. So they're easy solutions. Well, they're complicated solutions, but they're easy because we do that for you. You fill in a form for us, and then we can get all this in place for you. We check that your SMSF trust deed and the SMSF will is up to date, and we check to make sure you've got a successor director set up, and consider upgrading to a leading member SMSF. So what is a leading member SMSF versus a standard SMSF? So a leading member SMSF, the main benefit of it is it does not need to have all the members acting as trustee or being a director of a corporate trustee. The leading member SMSF isn't necessary for everybody, but there are definitely some very good places where you would want to have it. So one, for example, is I had an SMSF, well, my SMSF, I had my 4 children in it, my 4 adult children. They were just a pain in the butt when it came to signing end of year financials or anything that I needed to do. I had to get them to sign everything, and they were too troublesome, so I removed them all from the SMSF. Unfortunately, I've already done that, because if I'd known about the leading member SMSF at that stage, instead I would have upgraded to a leading member, which would mean that I could sign all the documents. The kids could have stayed in there and kept their super in with mine, which is beneficial because it saves on fees, but I wouldn't have had to go through the trouble of them signing. This could also be applicable if you have some members that are travelling regularly, so when you need to get things signed, they're not around to sign it. It can also be applicable if you want to be a leading member. So say, for example, most of the money in the fund is yours and you really want to control it. The other member may be a low-income spouse or a friend or an adult child that doesn't have much, and you simply want to be the one in control. So, and what you have to be a leading member SMSF is that you have to have an enduring power of attorney for the other members so that you can act on their behalf. And the leading member can ensure that the superannuation and death benefits are limited to the bloodline only. And the leading member has veto power over the fund, full control. So standard versus leading members, once again, just a bit of a table. The leading member enables a better director succession because you can appoint your successor in advance. So the control is strategic. You decide who is going to be the leading member after you. The replacement of the directors in a standard SMSF requires probate and legal personal representative appointment and trustees resolutions. In other words, complex paperwork, whereas the leading member SMSF is just instant. It just happens via the deed. There's no delay. The control risk, there's obviously less control with the standard SMSF because the leading personal representative may be hostile family. And unfortunately, this happens. You saw in those previous cases that happens. And maybe they're not hostile during life, but as I said, money does strange things to people, and they might become hostile when all of a sudden they've got control of all this money, and they all of a sudden hostile to your maybe children or to your spouse or to somebody else, and then they control it. Whereas the leading member SMSF is only bloodline and nominated people can take control. The death benefit decisions, in a standard SMSF, it depends on the binding death nominations and the surviving directors. Whereas a leading member, the SMSF will, and the living will bind control and distributions. So family wealth protection claims, standard SMSF is vulnerable to disputes, such as the case I mentioned before, whereas the leading member is embedded in multi-generational control and bloodline locking. All very complex, but don't worry, we can help you with all of this. So what if you have not left instructions or you have no family? Oops, there's a bit of a typo there. Something that a lot of people are not aware of, if you have left no instructions, your estate ends up with whatever family members the state and government can find. But firstly, the state and government take control, which is not what you want. And if absolutely no family are found, the money left in your estate ends up in the government's hands. So if only for that reason, consider this. Really, it's really important. You work so hard for your money. You know, a lot of people don't want to think about death, and they don't. I've had people say to me, I don't care what happens to my money after I die. But then when I say, okay, do you want to give it to the government? They go, hell no. So it is important to think about it and make sure the government don't get their dirty little hands on it. So if that's not what you want, you need to leave clear instructions so that you can gift your estate. If you've got no family, once again, don't let the government have it. Still do a will and estate plan and leave it to a charity of your choice. Unfortunately, a lot of charities out there waste money as well. And so for that reason, we have set up our own charity called Holistic Future Solutions, and we will be using the money to help the medically injured. So to help those that have been injured by medical negligence, which is a lot of at the moment, and we can help them either help them heal, help them get alternative therapies, help them take legal action against those that harmed them, just help them get their life back. So that is new. We've only finally got the government approval for it. So if you don't have any beneficiaries, consider talking to us about leaving your money to that charity. So ask yourself, if something happened to you yesterday, was there a simple, clear strategy that helped your family know what to do? I can ask myself this question and say yes, because it was only yesterday that I updated all of my instructions and gave a copy to the office so that it's scanned into my file, got a copy in my safe, and I've given a copy to one of my sons. So if something happened to you yesterday, have you got this in place? Who would take control of your financial affairs and your SMSF if you were incapacitated? Do you have a blended family, former partners, complicated family dynamics that could lead to conflict? Do you have a disabled, disadvantaged, or elderly family member who needs consideration? Are your EPOAs, that's enduring power of attorney, wills, trusts, companies, superannuation, nominations all aligned and up to date? Are you using structures that minimize tax, protect wealth, and prevent delays in distribution? Yes, it's important to minimize tax even after death. You don't want to work your whole life just to give more tax to the government. Do you have people or organisations you want to exclude from receiving your estate? If so, it's important to note them in your will. So if you need more information, we can build you a castle. We will have another video, the third in this series, coming out shortly with some really complicated strategies. So what does it cost and what can it save? The more important thing of that question, the more part of that question is what can it save? Because we mentioned earlier about those cases and the litigation and the lawyer's costs. So setting up a strong legal structure like the enduring power of attorney, SMSF will, testamentary trust will cost a few $1,000s, no doubt about it. But it can save you hundreds of thousands in legal fees and unwanted claim dispersals. So consider the cost to your family of doing nothing. Long and costly lawsuits, family disputes, assets passing outside your preferences, and more. Consider your funds going to the state consolidated revenue to pay for things that you don't agree with. A lot of us at the moment don't agree with the way our government is spending our money. And best of all, it costs nothing to find out more. So if you would like to know more, you can speak to us, myself, Mary Jane, and Grant. we watch our next video when we release it. Email maryjane@freedomffs.com.au or set up. You can also book an online consult with myself to start with. I will basically do the intake interview, find out what your needs are, and then decide whether we can help you or whether you are really complicated and you need grants help. So don't delay. As I said, these topics are difficult to talk about, but so important. You don't want your family having to deal with these concepts after you pass, because it will be even more stressful for them if you don't have clear instructions in place at a time when they will be grieving anyway. You want things to be nice and simple for them. So anyway, thanks for sharing. Thanks for listening, everybody, and I will see you again.